What's up, everybody? Welcome back into another episode of the Lawyer You Know podcast. I am pumped about Emily D. Baker. Don't forget the D. Joining me today, talking about Kohberger, talking about Karen Reed. All these cases that we thought were going to consume the next couple months of our lives are all seeming to come to an end. Even the Diddy verdict, maybe we'll get into. But we're just going to talk about all things lawyer content here on YouTube. We're also going to talk about what's next. What's on the radar? What is she covering? What is she following? What is she streaming? I'm excited. I'm sure you are too. Let's get into it. Emily, you're
Peter,
here.
good to see you.
You too. Thank you so much for coming on to talk about all these things closing at once. I think we have to start what was your plan the next 3 months? You were all in on Koburger, right?
I mean, I had definitely made sure that I could accommodate Koburger because I knew I wanted to cover it. But I also tell everyone trials go away. Trials go away. And I don't think of any of the big trials I've been looking at, they've pled like this. I think this is the first time really the trial watchers of your audience and mine are getting to experience trials can go away at the last minute. I've experienced that in my career. I know you have. Things get continued, things plea. I've had things plea during trial, which is always wild. You're like, oh, we were in trial and now we're not in trial. But it will all work out because there's always another trial. But I was very much trying to accommodate Kohberger. But now I'm going to just buy more concert tickets because there's a lot of stuff I can do in the fall that I was not planning on doing. And I can travel a little more this summer because my kid's on tour doing hardcore elite marching band, which a very select few of the population know anything about that, but it frees up a little bit of my travel ability. So that's what I'm going to do. But I don't think Kohberger is going to be done even at sentencing because I think that investigation into the media leak is going to keep going. And I'm really interested to see what happens with that. It's not going to be an in-court trial, but we're not done with the stuff coming out about Kohberger for sure.
Yeah. And somebody asked me, do I think that'll go away? And my answer was, it shouldn't. It really shouldn't. If somebody on the prosecution team or law enforcement team or somebody leaked information, we need to close that up, especially in this industry of everybody wanting trials streamed and talking about it and documentaries and learning more about our judicial system. Well, the rules need to be followed in order for people to understand and know what to expect. That's what lawyers like, right? We like to play by the rules so we know what to expect so we can prepare. And something like that just throws a wrench into it that lawyers can't prepare for. So you think that's going to continue?
Does Judge Hippler strike you as the kind of guy that's just going to let it go? I mean, no, I think this guy, he's a tremendously intelligent jurist and has a very good memory. He's also really a no BS judge. He reminds me more of an appellate style judge. He's more formal than some just state court trial level judges. And we saw that informality almost that I like about state court with Judge, where he's a little cheeky with the lawyers and he's like, oh, that's really interesting. Talk to me more about the field codes and the Magna Carta. I'm fascinated by this conversation where Judge H is like, this is what we're doing. This is when we're doing it. Do not talk to me outside of these parameters. I don't think he's going to let it go because it was a direct violation of his court order. And judges get real salty about violating their orders, saltier than they get about anything else. So when you look at a judge having their orders violated, it's the thing they're going to be the most mad about. And we saw this a little in Karen Reed too. People are like, why isn't the judge equally mad about this or that? I'm like, the judge is going to be mad about things directly said to the judge, about court orders, different than the other rules that attorneys and parties need to follow. Judges do not take it lightly.
Yeah. Well, good. I hope it does because I'd like to know what happened with that, if anything. And if it didn't, throwing shade at that side, we can put that away as well. So I think
it came from someone. They have things from the police file. They have video. It seems they have the entire dump of the defendant's phone. That's not a little violation. That is a massive, massive breach. And there's other cases where we'd seen pictures get leaked by the defense, and that ended up being a huge deal. It went up to the appellate courts about whether the defense was taken on or off.
Yep.
This is a much, much bigger deal to me than photos because it seems to be a ton of digital evidence that's then aired before the potential jury pool. It's a big breach. I'm not surprised he was mad about it, but I think everyone wants answers on that. And we're not going to get answers on some of the things in Kohberger people want answers on. So maybe at least we'll get answers on who gave all this information to the media.
Yeah. And I think right off the top, you said is kind of the first one that trial watchers have been watching that's gone away at the last second with the last minute plea, which is not unusual at all. I mean, how many prosecutors set multiple trials certain weeks or months or whatever it may be, because they all
Same day.
know, yeah, they all know most of these are going to plea, maybe all of them. And that's less work for the judges too, so they're not mad about it either. But were you surprised in this one with the lead up to how we got here? Were you surprised that he pled at this point and what he pled to?
I'm surprised more about what he accepted. I was curious because way down the road, when this case got going, it was very clear that one of Ann Taylor's goals was to litigate everything that could be litigated. And then when you started getting the evidence not being kept out and those motions were denied after the motions in limine and the suppression motions, the focus shifted a little bit to get the death penalty off the table any way possible. Discovery issues, bringing up the Vallow Daybell case, any way to get the death penalty off the case. So once all those doors were closed, I'm not surprised that the defense went to the prosecution and said, is there any way to take this death penalty off the table? I'm surprised a bit that the prosecution at this late period in the case said, yes, we're amenable to that. Then again, when I try to put myself in the shoes of the prosecution, you have surviving roommates that are gonna have to testify in a very public trial that are already having negative, experiences online. You have friends and family of the victims that are already having negative experiences online. That weighs really heavy on the prosecutor, and you also have multiple prosecutors from Latah County plus state level prosecutors from the AG's office, all taken out of their work for multiple years. The backlog that this case is causing is also substantial. So when you look at the difference between a death penalty conviction and a life without parole conviction, that line gets really narrow when you're talking about saving the trial or not going to trial. And then once the appeals are off of there, I think that's a huge part for the prosecution. Waiving all of the appellate rights and the resentencing rights and reconsideration rights is a huge part of it. So I'm not surprised that the prosecutors were willing to burden the hand versus taking it to trial, especially with those reconsiderations rights. Have you been watching the Menendez case at all with the resentencing on that
Yeah.
case?
Hmm.
So we when we talk about this, people are like, "Why is this a big deal?" You look at the Menendez case, you look at even the Scott Peterson prosecution. I realize these are both California cases, but fairly high profile. The death penalty came off the table in the Peterson case, what, 15, 20 years after conviction? So
Hmm.
when we talk about these things can change decades after a conviction, they can, and it keeps the case still being something that the families have to go through and have to have the conversation of, what do you mean the laws in Idaho changed and now you can get resentenced? What do you mean the laws changed and now you might get a new trial, or what is it? So waiving all those appellate rights is a substantial part of this because it gives some finality that he will always be in prison.
Yeah, and Lori Vallow's most recent Arizona case, which I wasn't able to watch the whole thing, but the prosecutor was asking for additional enhancements that don't necessarily apply now. But she's like, well, the law changed and we do have to find these specific, I think it was like verdict interrogatories or certain things. And, Lori's going to just agree to that and that's fine. But she was taking these extra steps thinking this could change in the future. I want to check all the boxes now because we have the ability to check the boxes. Now we can prove all this factually. So why not just do it? Because prosecutors do know that things change. I also think in a high profile case like this, two of the biggest factors prosecutors are weighing is number one, how much of a lock and a guarantee do I think this is? And if, you can be 100%, 99%, whatever it is, but if there's any doubts and you have the opportunity for, like you said, a bird in the hand to get life, I can understand why they go there. The other big consideration for prosecutors in a situation like this are the victim's wishes. And some of the victims have been louder than others, but we have seen and reports are that it's kind of like a split. Some of the victims' families were not in favor of this plea deal and wanted to continue for the death penalty. And a part of some of the victims' families were happy with the plea deal to get the finality to be done, to not have to sit in that courtroom and go through this trial and see their kids' friends have to testify and all these lives affected and being dragged through the next 3 months. So they were for the plea deal. What's it like as a prosecutor where you don't have consensus among the victims that you're trying to get justice for?
The thing that I think is hard, not just as a prosecutor, but hard for the public to remember, is that the role of the prosecutor is not as a representative of the victims' families. Even though you are trying to do justice for the victims, ultimately, prosecutors represent the people of their jurisdiction. So the people of the state of Idaho and Latah County. It's not just the victims' families. So while it's a consideration, the victims' families ultimately don't have the last word, which can be really frustrating for families and for victims, direct victims, when prosecutors want to plead a case and they don't necessarily agree, because ultimately the prosecutor can make that decision even if the victim or victim families disagree with it. And to have to weigh all of it, the prosecutors know after a long career that going through a trial, going through a penalty phase, getting to sentencing, at the end of the day, does not bring back anything that was lost and can't really right the wrong that was done. And they know from dealing with other victims' families that whether you get the death penalty or not, they know what the journey through appeals looks like for families and are trying to use their best judgment to really help give finality. And when you have people that disagree with what you're doing, you still have to do the right thing for the case and you have to do the right thing for the surviving roommate witnesses. And so I have to wonder if the surviving roommates are tremendously relieved because I'm sure the friends of the victims that are on the 911 call are tremendously relieved that they're not going to have to testify because I've seen them get dragged through the mud online. So you know that what was lost is not going to be brought back, but there's room to not drag those who have survived this through it anymore. And you have to balance those two, hoping that the families that are upset with this will understand in time and hoping that the individuals who lived through this, who were affected by this, who called 911, who found the victims, who were in that house, can start to close this chapter and move on too. Without their testimony and the cross examination and then the internet speculation and attention that comes living on forever. And that's a hard balancing act. But I mean, you've worked as a prosecutor too. A lot of times everybody's mad. So you have to do what's right for the case and know that, well, oftentimes everybody's mad.
Yeah. And things can happen and things can change in the future and stuff can come out. People can say things. And it's just like to have that guarantee. And again, a lot of people that were like, oh my goodness, how could they ever offer life? What a weak job by the prosecutor. What a lot. It's like people usually don't plead to life. Like we've had multiple trials on the defense side where, especially in federal court, they're like, you can have life or you can have life. If you want to take life, take it. If not, we
Right.
can go to trial. And those are the ones you almost always try, regardless of what your client's telling you or whatever it may be. It's like you don't really have a lot to lose at that point, especially in Idaho. It's not like the execution was happening quick over
No.
there, right? The death penalty could end up being life for a lot of people in Idaho. And so it was an interesting feeling. And I understand, from the victim's perspective and their families that wanted the death penalty, you can't ever understand what they're going through or, condemn them for wanting an eye for an eye.
No.
That's
Yep.
what happened to them. He's going to stand there in court and say he did it, so I get that, but the legal process is the legal process. I think they should have the opportunity to speak and share what they think and how they feel. And hopefully they'll get the opportunity to do that at sentencing. And I think the judge was right. And when he said, listen, my position here is I can't force the state to go for the death penalty. They've got to file for that. They've got to go forward on that. They've got to believe they can prove that. And I, as the judge, can't step in and force them to do that. Imagine if that is how it would work. That's just
Oh,
illogical.
no. There's a reason that things are separated, and the judge, I think, lined out the separations well. I understand the frustration. I understand the anger. I've been on both sides of that in my life, but I also know that at the end of the day, a sentence won't ultimately make anyone feel all that much better. I don't think that the victims' families are going to get the thing that they probably ultimately want, which is more answers.
Mhm.
And I think that's what a lot of people who were wanting to see this trial are also feeling disappointed by is I wanted more answers. Unfortunately, a trial at best will answer, are these actions a crime and were these actions done by the person that's been charged? It's more of who did what. It's not why. And what a lot of people want in this case is answers to why. And that's not what we're going to see at a trial. And that's not what we're going to see at a sentencing. And I don't think that's ever what we're going to see in this case is an answer to the question everybody really wants, which is why. And so I've seen a lot of questions about that. How can people force Brian Koburger to to say why? And the law doesn't really have a mechanism for that because the law is set up to answer who did what, and is that a crime?
When you guys are watching this, I'll be in Greece, and half my Greek wardrobe came from Quince. I absolutely love starting there for anything I need now. They keep it really simple, and it's great materials, great prices. I'm a brown, black, blue, white type of guy. I like to mix and match when I can, and Quince is perfect for that. So thank you for sponsoring another video, Quince. And one of those staples that you're sure to see plenty of pictures of me in while in Greece is the linen khaki pants that I'm going to mix and match a ton of shirts with. That's the type of staple that's simple, that matches so many different things, that I am going to wear over and over again on my trip because they're so comfortable, so nice, and so high quality. And you guys should stick to the staples that last with elevated essentials from Quince. Go to quince.com/LYK for free shipping on your order and 365-day returns. That's QUINCE.com/LYK for free shipping and 365-day returns. Quince.com/LYK. Yeah. And one of the reasons is the why doesn't matter as far as punishment goes a lot of times.
No.
And I think that every case is really cool and interesting and unique to learn from. The facts are always horrible. They're always dark. We're not covering cases that end happy or that have, some kind of great thing that happened. I say that all the time. Like, nobody calls me and is like, hey, I need your help for something good, or they're laughing and smiling on the other end. That never happens. But the really interesting part about this was, like you said, they got to see kind of a last second plea. They get to understand what a factual basis is, how simple some of this stuff can be, what prosecutors do in this situation, what defense attorneys, why you do it like this, and what the defendant has to admit to and not, and then what it can look like for somebody. And there's kind of two sides to this, and I'll start on the lawyer side. So we're all very big fans and proponents of the presumption of innocence and the Constitution and the rights of the defendant, and the rights of a criminal defense attorney, protecting the rights of the criminal defendant to say my client's presumed innocent. They're legally innocent as they sit here. The state has the whole burden to prove the case beyond a reasonable doubt. But this case, Ann Taylor went hard on my client is innocent. I'm representing an innocent man. An innocent man is sitting next to me. That's why all this stuff is so important, and used it in her arguments to the judge to try and get certain things done. And I also understand, the role of a criminal defense lawyer, but then the way that Brian Kohberger then admits to the guilt, admits that he did it, admits it was premeditated, to every single possible part of the crime that you can. What are your thoughts as a prosecutor who hasn't done, defense work on the defense side to kind of be put in that position? What is your view on how that timeline kind of works when you're sitting in the other chair and you hear a defense attorney do that? Is that to you something that's like, oh, here we go, another defense attorney doing this? Do you take some at their word and not others? What's that like?
It's interesting because the relationship that I had with different defense attorneys really helped inform that, because I would have defense attorneys that would say, can I come meet you in the office and sit down and talk to you? And they're like, look, I don't come to you often, but I want you to take a closer look at this case. I want to talk to you about this guy. This is why. And they will advocate for their client and talk me through it. And when they come to me on a rare occasion and are like, this case needs us to find another solution, I'll listen. I'm 100% there. If it is every single case, every single client, but you don't understand this one is different, they're not all different. Some of them just aren't. And so it really depends on the relationship with the defense attorney. And I have not seen Ann Taylor in action. I always see the defense as having a lot more gray area than the prosecutor, because they do. Their job is to represent their client zealously. The job of the prosecutor is to do justice, which sometimes means a plea deal, sometimes means not filing a case, sometimes means not offering a plea deal and taking it to trial. It really just depends, but it's not the same type of advocacy as the defense. So Ann Taylor, I always thought, was very mindful in her languaging, in saying the innocence phase, not the guilt phase of the trial, and saying the mitigation phase, not the punishment or sentencing phase. So all of the way she used her language was very much set up starting at the presumption of innocence. So that's really how I saw her advocacy, because everything stemmed from that, and it was part of her vernacular. I also see it as trying to make her client feel heard. She's not going to say the word guilt out of her mouth with her client sitting there, even when talking about the guilt phase of a trial. She called it the innocence phase of the trial, or the evidence phase of the trial. So I always saw it as advocacy, because yes, Brian Koburger sitting there before the evidence comes in is presumed innocent. And that's where I think she's making those arguments from. I didn't ever read that as her saying the same as like Alan Jackson saying, no, my client didn't do this. My client is innocent. We didn't hear Ann Taylor say, my client didn't do this. We heard her say, my client is innocent. My client has a right to this. My client has a right to that. So it's nuanced but different. So I always just saw it as advocacy because it was so ingrained in the way she was an advocate. And I imagine she does that in every single case because the languaging was so dialed in on everything. She never once called it the guilt phase, ever, which
Yeah.
I actually applauded her for. I'm like, she's got this dialed in, and her client has to feel incredibly supported. And if the conversations behind the scene were our goal number one is to get the death penalty off the table, she ran down every avenue to do that. And at the end of the day, when all of those doors were closed and all of those avenues were dead ends, she still accomplished what I think their ultimate goal was. And so for the defense side, that's advocacy gone well.
Yeah, I think she is a really, really good criminal defense attorney. I think she fought hard. I think she uncovered every stone, did every single thing that she could possibly do, and people are not going to like that. I always think when it comes to my client is innocent, my client is presumed innocent, legally innocent, the verbiage is really important when it comes to your candor and credibility as a criminal defense lawyer. And it's not just like with this one case. There's no just one case that makes a career. There can be one case that breaks a career, but
Yes.
it is with your relationship with the prosecutors, relationship with the judges. You want to be, you don't have to say anything, right? Like as a criminal defense lawyer, you don't have to say, my client sits here, they've done nothing wrong. They didn't do that. You don't have to say stuff like that. There are all sorts of appropriate arguments that are legitimate that you can make. And I think lawyers should be, criminal defense lawyers even, because I give them a lot of leeway as they
I
get.
do too. I get
Yeah,
a lot of
they,
flack for it, but I give them a lot more leeway than prosecutors because the rules of ethics have more leeway for defense attorneys than for prosecutors, as it should be.
absolutely. Absolutely. And but I do think there are lines, and I do think
Yes.
that it's again an interesting thing to look at in these cases, how different defense attorneys handle these cases and the decisions that they make. Every lawyer a million times in their career has to make a decision about what am I going to do? How am I going to be? What are my morals? What are my ethics? What am I willing to do? And sometimes it can come out in different ways during these arguments. But the more gripping part of the plea hearing was Brian Kohberger himself. The way he presented, the way he spoke, what he said, standing up, still looking mighty free there. I know he's probably got, shackles on, and somebody said they had a shock belt on him or something. I have no idea, but standing there, the way he spoke, the way he addressed the court, what were your thoughts when you watched it?
It was it was incredibly interesting. I'm gonna circle back to Ann Taylor real quick
Yep.
because I know you're ready to move on, but I had a
Oh, go
question
for it.
for you about Ann Taylor. A few hearings ago, the court was critical of Ann Taylor for taking on another death penalty case while she was doing this one. In hindsight, I now have to wonder if how long the defense had been discussing whether or not this was going to be the plan and whether she knew that the prosecution, when she went to them and said, can we take death off the table? It saves your witnesses from testifying and all of this. If she knew that this prosecution team would acquiesce to that, because she did take on another case while in this case. So it's now made me wonder if she knew if all of these things get denied, we're not going to trial because of taking on that other case. So have you thought about that at all, or what are your thoughts on that? Because she said, I'm swamped with this case, but then I took another case.
Yeah, it's kind of twofold. I think most jurisdictions do allow you to have multiple death penalty cases. I don't know if Idaho is one of them. So that wouldn't be. And again, that is one thing that she did. And it's kind of like people have different shticks, but her
Right.
thing was definitely like, this is so much work. I can't possibly do it. It's like lawyers do it every single day in multiple cases. Like just go look at private defense lawyers. They can have multiple cases that, whether they're death penalty or not, can be multi-month. Like my dad's tried a 6-month long trial before. Like it's just crazy. Like you find
Yeah,
a way to do it. Okay.
you find a
But
way.
now that's kind of on the one side. On the other side, I think that is your brain looking at it like, I'm a human being. I'm a lawyer. I know that if I was doing this for 3 years, I would not have taken that on unless I knew I was going to be able to do it. And I think that's a pretty logical explanation to get there. Number one. Number two, you also know throughout the process, like we would talk, right? If we had a case, we would talk. I would know where you were. If
Yep.
you were going to take death off the table, then I probably knew it at that point, so that I knew when I reached out, you were probably going to say yes. usually you kind of have a feel and you kind of give indications without saying it as a lawyer. And the same thing happens in the civil cases where, oh, I would never take that amount. I would never take that amount. Well, we're never going higher than this, or here's our bracket. I only hear one number when everybody gives me a bracket and it's the top number. So it's like, that's kind of how it works a lot of times when you're talking through these cases. So I think she probably knew it was always there. I don't know when Brian Kohberger, that's the more interesting
That's
thing to
the big
me.
question, right?
When did he tell her, okay, I'm willing to take this and I did it? Was it from the jump? Was it never until the last day? Was he still maintaining his innocence, but saying, I'm cooked. I don't want to die. I'll just take life. I don't know. Right. Because people
Yep.
think, oh, there's no way somebody could come in there and say I'm guilty if they weren't. It does happen. Usually not in these circumstances when you're taking life and admitting to these kinds of
Right.
crimes. I don't know if it's ever happened. But like, there's a lot going on in the background that we just will never know. I think that's a very logical thought, though, that she took that case knowing this was going to happen.
I thought it was interesting as I've been like, because it happened very quickly. I really appreciated as we get into the plea, Judge Hippler explaining why it happened so quickly. Not all judges will take a moment to explain, especially as he did, and apologize to the families and say this happened incredibly quickly. Though I did see some rumblings yesterday from the Gonzalez family that they think that the defense booked their flights to Idaho sooner. They thought they might have known what day this was happening. I haven't seen more from that, but there is some rumbling about did the defense know in advance? And it wouldn't surprise me if the defense knew first because Koburger has to make the decision first. So they would know it's a possibility before the prosecution would. Absolutely. But seeing him go through, I wasn't sure if the judge was going to do a factual basis or just read the indictment and say, how do you now plea and change the plea? But I think the judge knew that he needed to make sure that there was no avenue to say, oh, I'm just pleading guilty to get the death penalty off the table. And
Mm-hmm.
ask him, are you pleading guilty because you are in fact guilty?
Yep.
And, Koberger stood up, which they let him do, and said yes. And I think that's something that people weren't expecting or prepared for, to hear him in court, because he stood silent at his initial plea. I don't know if we've heard him acknowledge anything in court other than maybe the waiver of speedy trial. That might be the only time we've heard him say, yes, I understand, in court. He's been pretty quiet and letting his attorneys do the talking, as you should. So it was interesting to see how calmly and kind of unfazed he was in all of that. And then to see on the other side, the prosecutor get a bit emotional as he was reading in the really the statement of facts of what would be proven at trial. And part of me was like, well, if you feel that strongly about it, I mean, you could go to trial. But I get not going to trial. Um, so I think the prosecutor was in that position of, is this the right thing for the case? And at the end of the day, is this the same disposition? And I think it puts the case in a better position to waive any possible resentencing and reconsideration if the law changes. I think that is the biggest win for the prosecution. So it was kind of surreal seeing Koburger after all this time standing up there and say, "Yeah, I did it. Yep."
Yep.
And it was pretty quick, short answers. You saw him look to his attorney at times to address her. I was more interested in going back and rewatching the judge asking Ann Taylor if she had enough time for discovery, because it seemed like the two of them were a little bit locked in horns over that after reading the denial of the continuance.
Mm-hmm.
It seemed like the judge was just like, because he called it a sword in a footnote on the continuance. He said the defense is using the volume of
Oh,
discovery
yeah.
as a tactical sword. And he definitely was just like, and are you satisfied with the amount of discovery received? That moment was like, oh, this judge is not letting go of anything.
And have you had enough time to prepare and look at all other options and like he made her basically go back on everything she just filed in the prior motion, which I thought was kind of interesting as well. And not necessarily something that you need to plea. So
Correct.
that was one thing I thought was a little extra. Like I, as a defense attorney, be like, no, give me the continuance and but that's not, it's the client's decision. Right. And
Right.
I've told him, here's what I've been able to get with this time. And you, the judge, said we have to go to trial. So he has to make his decision now. So whether or not I think I need more time is not really relevant here. It's whether he understands we lost that motion and are going to trial. So that
Right.
was one part of it that was a little bit, I agree with you. I feel like it was the judge doing that because he wanted to. Yeah,
He wanted the
exactly.
answer and he wanted it on the record and I think he wanted no ability for anyone to come back, whether it's Ann Taylor, other defense attorneys, appellate counsel, anyone to come back and say Brian Kohberger wasn't properly advised because his counsel did not have enough time to complete discovery or investigation. And I think if appellate counsel did come back and try to say something like that, the record is now incredibly clear and that he did that to protect the record. But also, it was interesting watching her kind of pause and look at the judge and be like, are you really asking me this right now? So you and I read it kind of the same way on in that moment, does she fight with the court and say, "Well, actually, Your Honor," and blow up the entire plea? Or do you say, "Yes, we've run down every avenue," because it seems that they have, in over 2.5 years, had a pretty thorough run through. I mean, every lawyer wants more time always. We're never gonna get the amount of time,
Mhm.
ever. You never get the amount of time you want. You never have the amount of time that you want. But this case did not move quickly. So she has had a very, very long time to work on this case.
And one of the big things I felt about this case is everybody's like, "Oh, it's only been 2.5 years. Lots of average case 3.5 years. Cases take longer." Not every 2.5 years is the same.
Mhm.
And you go look at, I mean, pick almost any criminal case. You can pick Adelson, you can pick Corey Richins, you can pick any of these cases. Not as much is happening in those cases as happens, it seems like, every day or week in the Brian Koburger case, because again, this is basically her only case. Everybody else's lawyers have other cases. And so every 2.5 years is not created equal. They did a lot in this
They
case,
did
like you said.
so
Like,
much
she was able
litigation.
to, yes,
Yeah. It was
absolutely.
no one can say that they did not bring every motion that was within the bounds of bringing a motion. They brought every motion they could, and they had a very, um a well-staffed defense team.
Oh, yeah.
The court did not put parameters on how many attorneys they can have. So they had attorneys working just on motion practice. They had research attorneys. They had a very well-staffed defense team, which for public defense is kind of unusual. So for a public defense case, they had more attorneys than I think we've seen in just about any case with a public defender or an appointed counsel. So it was, there was no lack of motion practice in this, which does make it hard to go through discovery. But that's true for the government. I mean, they kept the prosecution in motion litigation for 2 years very effectively.
And that is an interesting thing, because one of the uh, conversations I was having after Diddy and Karen Reed, kind of back to back, getting, wins, split decision wins, and obviously the defense attorneys that they had, and, money can buy you X, Y, or Z. I don't think money would have bought Brian Koberger a better defense in this case. I honestly don't.
I don't think so either. And I think that when you're looking at particularly smaller jurisdictions, the attorneys that know the lawyers and know the judges have a leg up than anyone else you can hire. They really do. They know those courts, they know those jury pools, different than also a large jurisdiction like New York, which is going to be a little easier, especially for somebody like Brian Steele parachuting into the Diddy case. It's going to be a little easier to gauge how the U.S. attorneys are going to operate and look
Mhm.
at a jury because it seems Brian Steele is very familiar with New York, right? So it's a little easier there, but I don't think any amount of money would have bought a better defense in this case.
Yeah, and I think that's another good example. That doesn't happen for everybody that's indigent and has a public defender, right? It's very different for every case. And that's kind of the tough part about the legal system. It's never going to be perfect. And money definitely provides you a better chance at it. But he didn't have it. And he got a really good defense, I think, when all was said and done. But Brian Koberger did it. Still people trying to say he didn't do it. I was like, I don't know if my man would have stood up there and said, "Yes, I did it. I'm pleading guilty because I'm guilty. Yes, it was with malice aforethought. Yes, I did it with this weapon. Yes, I did it to all four of these kids." Like, it was eerie
I
to watch, but I'm going to believe him when he says that.
I'm also gonna believe him when he says that because in a lot of the high profile murder cases, I mean, if you look at the Murdaugh case, he's still maintaining his innocence.
Yeah.
He went to trial and was convicted. He testified. He's still maintaining that he did not commit those murders. And when you look at cases that are overturned later on appeal or done with the Innocence Project, one of the things you see in all of those cases is they went to trial and the defendant maintained their innocence through trial, through sentencing, through post conviction, all the way down the road. I don't think I've ever seen a case where evidence has been uncovered down the road that somebody who pled in a capital homicide case didn't do the thing. In smaller cases where you're looking at, well, I'm going to be in custody 2 years before I go to trial, or I can plea and be out in 3 months. In those cases, there's a little different cost benefit analysis, but capital murder pleading to a flat life period sentence is a different thing because there's no benefit to the defense. There's no getting out. There's no, the law might change and you can get out. There's no, the benefit to him is not having the death penalty on the table. And so if you're looking at the evidence against you and going, well, I know what I know and I know what they know, and so I rather have the death penalty off the table, I'm going to believe him when he says that he's pleading guilty because he is guilty.
Yeah. Yeah. And I mean, you can even look at the Nicholas Cruz case in Florida where it's like, you can beat the death penalty potentially. So it's like, if that's really all you want, I think that we should take him at his word. I guess that's kind of the ribbon wrapped on that, or the bow tied on that one.
Yeah, I'm not going to fight with him over that. And even when people are asking for, and I think I brought this up when I was talking about the case during the change of plea, is that a lot of people are like, the judge should force him to explain why and force him to give an explanation. But we got that letter in the Laundry Petito case. Yep. And even then people are like, well, this is just gaslighting bullshit. I'm like, well, I don't know what one would expect Brian Kohberger to say. And when we looked at Brian Laundrie's letter, I read that letter and went, well, that's not all of the truth. That's what you want to say, but that's not all of the truth in this case. And we know that. So I would expect more of the same from Kohberger if he was ever to speak about this case. I don't think anyone will ever really be satisfied with the answers he would provide or trust those answers. And that's the hard thing about this case, is people want to know why, to give some understanding, and no one's going to get that answer. And that's frustrating, but a trial wouldn't render that answer either way.
That's a great point. People would still argue with whatever he said. Like, that's not enough, I need more, or no, that's a lie, or whatever it may be. They would still, and it's not like he's going to give some good reason. Okay. We kind of know that.
There's no good reason to murder 4 people. There's just no good reason.
Okay. Before we get to Karen Reed, might as well just hit on Diddy real quick. Were you at all surprised when you heard that verdict?
I was surprised on the trafficking. I understand the RICO, and I can understand where RICO can be a lot of things and be hard for a jury to wrap their head around. But I was surprised on the trafficking, especially when they found the transportation, which leads me to believe, and I did not watch every single day of the tweets coming out of this case, because it's very hard to just read about it and not see it for yourself. But I can only imagine that the defense arguments that this wasn't coercion, this wasn't force or fear, is what played into that decision on the trafficking. And that was their strategy. The defense strategy was to go in and admit the awful, but then recharacterize it as, this is just within the relationship. This isn't coercion and force and fear. This is domestic violence, not human trafficking. And it seems that defense was successful for them. And it's one of the things prosecutors have to be mindful of, is that not everyone understands. If you have text messages where the victims seem to be willing or seem to be placating, it takes a lot to explain that behavior. And some jurors are going to be like, well, I don't agree. These are adults. And it seems that that's where we're at with this jury. What was interesting is the person they brought in to explain that dynamic of coercion was Don Hughes from the Depp Heard case. And if there was testimony I wanted to see happen, I was interested to see that testimony of Don Hughes, because I know during Depp Heard, her testimony was not always well taken. So I just wonder if her coming in as the expert on coercion was helpful or not.
Who called her as an expert, the defense or the prosecutor?
The prosecution.
Interesting.
The government called her as their expert on coercive control, coercion, and domestic violence.
That's interesting. Yeah, I didn't even know that. I know there are so many, at least last names, that I have heard before involved in this case. which really makes it interesting as far as I would have loved to watch it, especially now seeing how the verdict was split. Why did they come to this decision? Like you said, was it the forced coercion? Was it personal versus commercial? Was this just relationship stuff that was, a crazy celebrity life that we don't understand but not criminal or not this type of crime?
Right.
Was it more domestic violence? Whatever it may be. There's so many different options that they could actually get here. People were saying it's an illogical verdict. I don't know if I would say it's illogical. I can understand how they got there, especially with some of the reports that were coming out. I am just surprised because usually when you can pile on and make somebody look that bad sitting in that chair, the jury is usually not going to. And maybe the jury thinks that this was a split baby and that these two crimes were, just as bad as all the other ones. That's possible as well. But when we say that the federal prosecutors win 90+% of their cases, this would not be considered in that 90+ percentage, even
Oh
though
no,
it's a guilty verdict.
this is definitely not a win for the prosecutors. And I might feel differently if they had come back on the trafficking and not the RICO.
I agree.
RICO can be difficult. But if the jury felt that the government was just piling on to make him look like a bad dude, and they're like, this is personal relationship stuff, why is the federal government involved? Which was really the defense's argument, then all of the government piling on is just going to turn the jury off. And they're going to be like, this is overreaching, this is too much, and we don't agree. So it's interesting to me with the videos of Cassie being assaulted and her testimony that they did not find the force, fear, coercion, because
Right.
that seems to me to be the big difference between the trafficking versus the transportation. And they found the transportation. The transportation is pretty undeniable. I mean, it is much
Oh, yeah.
more fact based. Did point A, point B for purpose. The force, fear, coercion becomes a bigger conversation, and it's sometimes hard for people to wrap their head around. And the defense is saying, you don't have to wrap your head around it because these are adults. They made their own decisions. This was not a good relationship. This was not good behavior, but it's not criminal this way. And it seems that the jury was like, we agree. So it doesn't seem illogical to me,
Yeah.
given the elements of the different crimes. But it's hard for me to wrap my head around knowing what they knew about the force as to Cassie particularly, that they did not find that to be trafficking. That was surprising to me.
Because it's one thing if it's just he said, she said, and there's only text messages going back and forth. But when you have the actual videos and corroboration with what that relationship was actually like, regardless of what her mindset was like while in the relationship, which we know is not always a normal mindset or how it should be, especially when you can couple it with the videos and other evidence and testimony. That was a little surprising to me. I heard everybody felt like Cassie was really credible in there. It
Yep.
seems as if the jury, and I was thinking maybe there was a way they could have got to guilty and still found her credible, but I really don't know if there is. I feel like they would have had to not believe her version of the events really to come back with this verdict, which maybe it's the $20 million settlement. I think that could go either way. It's like, why
Yeah.
would this guy pay $20 million if he didn't do anything wrong? Or is she just out for the money or whatever it is? You never know how a juror is going to look at that stuff.
And there were a number of corroborating witnesses that saw it. So yes, the trafficking is a bit confounding to me. And I don't know if that's the jury saying, you know what, this is an overreach for the feds and we're not doing it. I don't know. I don't know if any of the jurors have spoken. It'll be really interesting to me if they do, though. I have to wonder if any of those jurors go on social media and are aware of or see how the jurors have been welcomed online from the Karen Reed case. They might be disinclined to talk about this case at all because this case is also polarized. And the jury might be like, I don't want anything to do with any of this. Leave me alone and let me go away.
Yeah. Yeah. I mean, you're such a pro too, because that's the best transition we could have into the Karen Reed trial. So the verdict comes down, guilty on OUI, not guilty everywhere else. Were you surprised? Is that what you expected? What were your thoughts when you heard the verdict initially?
I wasn't surprised. I was traveling, so it was a very stressful day to even try to get online and stream the verdict. It was a disaster for me, which I felt horrible about because I was also then stressed and anxious. Like this is stressful. I was surprised that when they asked the questions that indicated to me they were leaning towards just the OUI, that they didn't come back more quickly. That surprised me more than when we ultimately saw that that was the verdict. So I was not surprised that this was the verdict. I was not surprised with the explanation the jurors have given down the road. I was surprised that it took them that long after they asked the questions to come back with that verdict. And then the false start with the verdict, I thought was going to be a false start based on filling out verdict forms, which verdict forms are confusing, these maybe more than most. But then when the foreman talked about the fact that that was somebody really having second thoughts, I was like, "Oh, this wasn't a verdict form issue. This was second thoughts issues. That's interesting." That I was not expecting at all.
Yeah, and the foreman also talked about people. I actually think maybe a couple jurors said something like this, that there were some people that initially felt like she was guilty, and and he said something like feelings and thoughts and whatever, not necessarily the facts and the law, and they had to bring them back to the facts and the law and eventually convince them that she was not guilty on at least some of these charges they were discussing. I think the juror interviews have been incredibly enlightening and interesting after the Karen retrial. What has stuck out to you when you've heard them?
I think it's also been really interesting hearing what evidence they took into account, what they discounted, how they felt about certain things, how they felt about the holes in John O'Keefe's hoodie and Brennan pointing those out, how they felt about different witnesses, and it's so different than what we heard from the juror that spoke from the first trial. And I think it goes to show that there's a reason that juries are made up of numerous individuals, often 12, because deliberation is incredibly important and being able to talk it through with other individuals is incredibly important because people can come into the jury room thinking one way or leaning another way and then hear somebody else's perspective and go, "Oh, you know what? You're right. I agree with you." And that's keeping an open mind even if you have an opinion is something jurors are asked to do. I think the jury interviews have illuminated too that jurors are coming out of their everyday lives. They're not given any special instruction other than those jury instructions at the end. They're not told how to be jurors. They're told to listen and keep an open mind. They're not told anything beyond that. And then they get put into a room together and are like, go figure it out. Good luck. Here's the jury instructions. And I suspect people think sometimes like it's got to be more than that. It's not more than that. And so the jurors speaking about how much they respected one another and how they respected their deliberative process is a really nice thing to see. And that's I think the thing I've been most happy to see because in California we talk to jurors pretty often after trial. I don't in Florida. Do you guys talk to jurors pretty regularly after
I would
trial?
say maybe 50% of the time we get to talk to them, and
Yeah,
not all of them.
it's almost every case they give jurors the opportunity to talk to the lawyers if the jurors choose to.
Mhm.
And so you get a lot of that feedback, but it's always, I think, nice for me to hear, but also nice for everyone to hear that the jurors respected each other. They listened to each other. Reasonable minds can differ, but they talked it through and came to a consensus. That's
Mhm.
the way it's supposed to work. And it's nice to hear that it worked. The jury system worked as intended, where you put 12 people in a room and let them decide what the facts are. And they did that, and it seemed like they feel pretty good about the result that they came to, and I like to see that as well.
And so many of them talked about burden of proof and reasonable doubt. And was it proven? Sure, it could have happened. Do you think she's factually innocent? A lot of them said yes, but a lot of them said, I don't know what happened
Right.
because it was so difficult. And if they're going to reopen the investigation, they still have problems that they did in this investigation. So they really looked at it from my perspective the right way. And a lot of that had to do with what I felt was like a stark difference in the defense from trial one to trial two. Would you
Yeah.
agree that it felt completely different, even though we're dealing with the same facts and they did sprinkle conspiracy in there, that it felt completely different this time around?
It was a completely different defense. It was a completely different prosecution as well, and I think the defense used that to their advantage because it was what didn't the prosecution show you, what didn't the investigation do, and it put the focus back on what is the prosecution proving. I think the first trial, the defense really pulled the burden onto themselves, even though it doesn't belong there, by saying at the beginning with Yannetti saying Karen Reed was framed. I think a lot of jurors are going to be like, oh, tell me more about that. Show me how she was framed. Prove to me how she was framed, which is not what they have to do. And so by putting in the odd behavior and letting it linger as like, isn't this weird that they didn't investigate this more? Left the jurors with too many questions. And those are the questions they said were doubt. And I think that's exactly what that is. There are too many questions. And if there's too many questions, how can you be convinced beyond a reasonable doubt? And Massachusetts language is that pretty heavy
Moral
with
certainty.
its moral certainty. I think it might be one of the heaviest languages I've seen in any jurisdiction on what is reasonable doubt, beyond a reasonable doubt. It's heavy. It's almost beyond all possible doubt, which a lot of jury instructions in other jurisdictions say beyond all reasonable doubt is not beyond all possible doubt. They're saying beyond all reasonable doubt and to a moral certainty. It's it's heavy languaging, and it really tells the jurors you must be certain, certain, certain. And these jurors said no way. And I think it was a better plan for the defense than trying to prove um, what everybody was doing and how. I think leaving those questions lingering didn't invite the jury to ask the defense, well, how was she framed and who did it and who did this? And so I think it obviously worked much better for them, but the prosecution should have seen that coming. And there were times where I thought Brennan's closing was almost written to the first trial, not to the second trial.
Like he had it prepped before the trial started.
Mhm. Yeah,
Yeah.
absolutely. And he really attacked the conspiracy of it all. And that's the defense was arguing the investigation, not a grand conspiracy. They left a lot of, isn't that weird? But they didn't go after it the same way. And I think Brennan got a little lost in the sauce with that.
Yeah, I think the defense did so much. Like when you talk about a jury is given this stuff and then sent back there, well, the lawyers are the ones that have the job to teach them what they should do. And I think that from beginning to end of the case, the defense lawyers were the ones that focused on what's the jury's job, what do they do, what are the rules, as opposed to last time when the jury only hears beyond a reasonable doubt. Yeah, you don't have a burden, but you're saying she's framed. Well, prove to me that she's framed, and I only hear this moral certainty. I'm definitely not certain she was framed. So now what the heck do we do? Like
Yeah.
that creates that kind of confusion that I think completely went away in trial two when they focused on that burden. I think it was a much, much better job. But I also think some of the strategic decisions Brennan made, like you said, even though he's much better at presenting the evidence and much better courtroom demeanor than Adam Lally, it was Adam Lally's more like, okay, I'm just going to get up and prosecute my case. I'm going to just put every witness up there that can say something. I'm going to do it in a timeline order. I'm going to tell them beginning to end what happened. And when you have that many people coming up and saying, he didn't come in the house, I didn't see him, it was Karen Reed, basically. You have all those people. Maybe it's more effective. Like he convinced more people than Hank Brennan did. What did you think about some of the decisions, like not to call Proctor, not to call Higgins, not to call everybody in the house that Hank Brennan made real time during the trial? What were your thoughts?
I constantly found myself going, bold strategy, Cotton. Let's see how that plays out. Because I don't know if I can adequately express the level of maybe confidence that it would take to be like, nah, let it ride. I'm not calling them at all. There were times the way that Brennan prosecuted the case felt much more like defense strategies
Mm.
because it felt like he was like, "No, I'm not gonna answer those questions." It's like, your job is to answer those questions, though. You can't leave questions lingering, and even in his closing, he said, "That shows you that it's possible." I'm like, "Sir, you're not proving possible. That's not what we're here for." So it definitely was uncomfortable for me at times being like, "How are you choosing to not call these witnesses? What is happening? And how are you comfortable arguing, oh, this will come up in a later witness with like the DNA and then not calling that witness?" I don't think I even would have thought of that. And technically, I had to go back and look at the rules. I'm like, is that even, well, I guess it's proper. You can ask questions if it could be evidence, but prosecutors don't tend to see cases that way,
Right.
where there were times that the decisions he was making, I'm like, that is not coming from a line prosecutor brain. It's just not
Exactly.
operating that way. And I think, well, I would love to talk to Adam Lally at some point about these cases. I'm sure he never will. But he definitely got up in this case and was like, this is my list of witnesses. You're going to hear from everybody. The prosecution's not hiding anything from you. You're going to hear what everyone has to say, good, bad, and ugly. Brennan made some real strategic decisions that I think backfired because it was a red flag for the jurors based on what they said of who the prosecution didn't call. And I thought that it might be, and I know you thought that it might be too. It's like, that gives the defense a lot of room to argue, what didn't they show you? And when the prosecution is not showing the jury everything, jurors hold it against them.
And then speaking of Brennan as a prosecutor, um, how much did you cringe with the holes in the sweatshirt, the x-rays, the look over here, well, Mr. Alessi, I guess, wants me to show you every transcript. So because he requested it, let me show you this transcript, and the windups he had to all these questions. That's inappropriate, improper. We all know that. We are not allowed to ask questions we know that are improper and objectionable and inappropriate. Yet he continued to do that. What was the vibe like over there in Emily Baker's head?
I was not very happy with it. And again, I got a lot of flack about, well, you're treating the prosecution differently. I'm like, their job's different. So yeah, I am. I'm going to hold them to a different standard. Their job is different. And again, there were a lot of times where he was doing the prosecutor's job like a defense attorney. It doesn't work when you're the prosecutor. That's what you do as a defense attorney. So there were times that his style definitely rubbed me the wrong way. I was optimistic when there was a new special prosecutor. I was optimistic that fresh eyes on this case might reach a different result than a retrial on absolutely everything. And my optimism was it came squarely back to bite me in the ass on that because I was much more grateful for Lally at the end of the second trial than I
It's
was at the end
crazy.
of the first
Would
trial.
you have ever thought that after watching the first trial? I never would have
No.
thought we would be sitting here being like, maybe Lally did better. I don't know. It's
His
crazy.
questioning style, Lally's questioning style was difficult because he asks 3 questions at a question, and it just grated on my nerves. I'm like, "Ask a direct question." Brennan's questioning style, indirect, was much more succinct. He got right into it. He got rid of the witnesses that were fluff, but then he kept going and cut away too many witnesses, and then as he got into being able to cross-examine, it was a default back to really heavy-handed snark, really, really aggressive tactics. And I find that while a jury might not hold that against the defense all the time, they will hold that against the prosecution because it feels too heavy-handed.
Mhm.
And so when the jury's not with you, you haven't earned that level of snark and of frustration. And he was leaning into snark and frustration he didn't earn. And there were a few times that I think in almost a case-changing way, it bit him. The first one I think of is with Dr. Russell being able to explain Karen Reed's grief and stress.
Mhm.
Brennan walked himself into that answer with a witness who is highly intelligent and not a big fan of his. I can't believe he did it. He walked into a few answers like that with the experts that were shocking to me. I was like, how did you think that this was going to go well for you? And these answers, the defense at the time was like, oh, we're putting that in our pocket for closing. That is too good. We're not following up. We're going to hold it right here. And they did that well because it would take a lot of restraint as a lawyer not to follow up on that gold that the witnesses left.
Mhm.
But they did it with the other medical witness too. When they said, well, Brennan was asking, did you care about the speed of the car? She goes, well, he wasn't hit by a car. So no, I don't care. Okay. That that's a terrible answer for the prosecution, great answer for the defense. And then he kind of sat down after that. He was like,
Yeah, I feel
"Oh,
like he was
come here."
starting to get beaten down. Like I was getting that vibe from because he kind of has the vibe and the style of if the jury's with you, this is going to be a quick guilty verdict because they hate everybody just as much as you hate everybody. If they're not with you, you're going to lose.
Yep.
With the style that he had.
They were not with him.
Yeah.
And the experts were not going to be pushed around by him in front of the jury. And I think he perhaps was confident by maybe the internet's reaction because there were lots on the internet, which surprised me when he was going after people in the voir dires that were like, yeah, get him. And I don't think the jury was feeling that way about how he treated some of the experts. And I was a little critical of Dr. Russell when he asked about her memory and she kind of gasped. I'm like, well, if you're going to be an expert, this is going to come up. But I think the jury was with her in that moment, was like, how dare you, sir? And I'm kind of jaded as an attorney going, well, these are the questions that come up and he's asked almost every expert. But the jury, I think, reacted to that the same way she did with like, how dare you ask me that question?
Mhm.
And I think her reaction was incredibly genuine. I don't think she was,
Exactly. That's the key.
yeah, she was not putting on. She was genuinely stunned by that question. And she's not an expert in this way regularly with attorneys like this. And so I think it was very much a surprise to her. And I do think those things hurt Brennan's credibility with the jury. And then when you get to the holes in the hoodie, it really hurt the credibility. I was frustrated by those rulings from the court that the court did not let them go further to correct that error. I was incredibly frustrated by that. I think they should have had room to correct that error more because it was Brennan can say one side and down the other that was an error in the moment, but the hoodie was up there for him to ask questions about. So I still have questions about that. I don't think he just got lost in the moment with look at all these holes. And if he read all the reports, he would have known where those came from. And we never saw Adam Lally pull stunts like that. I mean, we saw a lot of questions about was it snowing and who sat where at a basketball game, but those are annoyances. They're not egregious actions in front of the jury.
He's a
So
different guy, no doubt. Different guy than Adam Lally. And I also thought with Brennan's attack on some of the, ARCA signal deleting stuff, you said, well, if this isn't going to be helpful, I'm not going to say it, whatever it may be. I almost felt like it was the same vibe as what the defense was trying to do with the conspiracy, in that, am I supposed to sit here and believe this guy that works for some totally separate company that works with the DOJ and works with the NHL is going to like lie and delete stuff that's important for this random case in Massachusetts? Like, am I supposed to believe that as a juror? I think it fell flat. And
yes,
he kept trying to get the jury to infer things that were not even helpful to his case. That's what I think. It was almost like the first case too, where the defense would impeach unnecessarily. It's like,
yes.
you're not winning here. It's so clunky. Like, move on. You don't need to impeach them on this individual point. And I felt like they did a much better job of that in the second trial as well.
I think so too. And there were times that it felt like Brennan just wanted to win cross-examination, like a battle of the wills with the witness. And he lost the point of the cross-examination because he got too into that. And he's like, I'm going to make this point. And when he got into that with Rentschler and the ham sandwich, I was like, you've got to be kidding me that we're fighting over him eating a sandwich before he goes to the airport. It felt like that Depp Heard moment where they were going after Dr. Curry about her husband bringing muffins into the office. I'm like, why? There's nothing nefarious about this. But then again, this Brennan calling attorney Alessi the entire trial also made me kind of nuts. So, and I mispronounce everyone's name, but once I'm corrected, I generally get it right. It just started to feel too much with him calling Mr. Alessi. But I do think bringing Alessi on to take up some of those expert witnesses also tamped back the defense's going after everyone, because when Alessi was asking questions, even though there were times that I was like, oh, now he's trying to win physics with the expert.
Yeah.
It wasn't snark. It was trying to get to the facts. It wasn't just trying to beat the other person. And so when the aperture expert Welcher was fighting with Alessi, it felt like the witness was being super evasive and Alessi was just trying to pin down an answer. There's times with Jackson where it feels like Jackson is just in a battle of the wills and he's like, I'm going to win this and you're going to acquiesce. Alessi has such a different style that the witnesses felt like they were being evasive when they were being questioned by him in a different way.
Yeah, I thought Alessi was a great addition just for all the everything he was able to carry. They felt a lot fresher this time than the first trial. And I do think that he likes to go after the expertise of the expert with them, which can be dangerous. But when you have a case like this where the expert just wants to say, yeah, it happened because I said it happened, that's where it can become helpful with somebody like him with his understanding to not just say, you can't just say it happened. Like, there are rules to this. And because you're a scientist, you have to stick to this. And you didn't. You really didn't tell us anything. And that's basically what everybody confirmed the whole time when it came to Welcher. And Hank Brennan wasn't done just with the trial. Then he comes out with a statement post-trial after Morrissey said the jury spoken, where it's like, that's fine. That's fair game. Jury spoken. But then Hank Brennan takes it further. I did a thorough investigation. There's only one person to point it to, and that one person is Karen Reed. What did you think about that?
First, a line prosecutor would never. Like, a line prosecutor would never. Once your boss has spoken, your boss has spoken. Or once the office is like, if the office has a media relations person, they release a statement for the office and you're done. So I didn't even think we'd see a statement from him because the head of the office had spoken. Also, to try to still say the jury was wrong was wild to me. And the first time I read it, I think I buffered. It took me a couple readings of it, and then I read Jackson's reaction to it, and I was like, this is worse than I thought, because I'm still buffering that he's even giving a statement, and the statement not being, this is not the result we had hoped for. We are seeking justice for John O'Keefe and his family, and our thoughts are with John O'Keefe, his friends and family. The jury has spoken. This case is resolved, and I'm thankful I got to try to pursue this case on behalf of the district attorney's office or whatever. I don't think he should have given a statement. He definitely shouldn't have given that statement, because it furthers, I think, the vitriol online. And I think it continues to fan the flames. And I don't think that's what's helpful for the residents of Canton and for everyone in the local Boston community. I think fanning the flames is not what's helpful. And he just can't read the room on that. And that's incredibly frustrating because everyone who I've talked to who lives locally is exhausted and frustrated and tired and really distrustful of whether their elected officials and law enforcement are doing the right thing. And that wasn't acknowledged by Brennan at all. So
Yeah,
I
and
don't know if
that's
you've had the same experience with those who live locally, but
oh yeah. And what's interesting is there's some people online and some pushback and people I'll talk to that, think she's guilty, think she did it. It does seem to be, I don't know if it's because of the verdict, more of a minority, but like the real people I've spoken to or people that I know that are from there or have family or friends from there, it's all a very similar thing. Like you're just saying it now. We've always known it was corrupt, or they knew that, oh, yeah, they know this guy who knew this guy. They're not surprised that he might be involved or whatever it may be. I got a lot of that. But what have you thought? Because I kind of thought maybe this is just a one off. It's, Karen Reed, everybody told me it was going to be like this. Do you think this is going to be specific to Karen Reed, or do you think people are going to be more invested in these high profile cases than ever before because of the streaming platforms, the social media memes, everybody around the world watching it? Do you think this is something that's going to come, or do you think it'll still be kind of more of a case by case basis?
I think the intense interest in local cases, including the Birchmore case,
Mm-hmm.
the Walsh case, and others, I think that is not going to go away. And I think it's going to grow nationally instead of just being regional because of the Reed case. So I think there are all eyes on, Boston state troopers and others to see what's going on in these other cases because the Birchmore case, though going federal, it's a really interesting thing to have the feds come in and charge someone after a local investigation. So I think there will be a lot of attention there. Most of the cases that we see, especially the criminal high profile cases, you get to the end of the prosecution's case and you're like, I wonder what the defense is going to do with that because there's really not there's not a lot for them to do.
Mm-hmm.
So we'll see how this plays out. The Karen Reed case was very, very different than that. And I think each case is different. And not trying to make every case a Karen Reed case is going to be important. But I say this about the Depp Heard case too. A lot of cases come up and people are like, oh, this is a Depp Heard case. No, Depp Heard is a Depp Heard case. Each case is different. Each case set of facts are different. But the spotlight on Boston, I don't think is going to go away anytime soon because they have a few high profile cases. And looking at what officers are involved and who's downloading the phones, those questions aren't going to go away anytime soon. And I can't imagine living locally and feeling like, well, can we trust any of these prosecutions and how frustrating that is? And then for those who feel like this verdict isn't justice to be incredibly frustrated in everything that's happening. And I think for me, that falls at the feet of investigators. I know that not everyone agrees with that, but that's who is supposed to investigate. And if the federal investigation doesn't go anywhere, which I kind of suspect it won't, there's not going to be a lot of resolution on that. Do you think that the federal investigation is going to go anywhere with the Reed case
My
and beyond
guess,
that?
my guess would be no. My guess would be no. And I think that the way the defense won trial two feeds into that even more. Like, what do we really have? What can we really prove? Definitely enough reasonable doubt. Like you said, what's the defense going to do in most trials? Any one of the 25 things Karen Reed had in this case, defendants would love to have in most trials when they're going to trial. I also think that level of people really believing she's innocent, or even if you don't think she's innocent, absolutely not guilty, and it's still pressing forward and going this far, I think added to the interest. I think bad cops, bad police investigation, especially highlighted by Proctor, not just like dropping the ball or negligence, but then you have Proctor on top. I think that made this case different. I was one of those that did think like nothing's going to come close to Johnny Depp, like the interest in what people had with Depp v. Heard. I don't know that that's true. Like, I think this type of case, locally, obviously people cared about it more, but nationally and internationally, I do think that people are starting to get more interested, more educated, understanding the process, understanding the issues, seeing how maybe it should go or shouldn't go. And when they see something that makes them go, I think it really draws a lot of interest now that even 5 years ago was not there.
I agree. And we saw that intense interest in really specific cases in decades past. And it was one case every few years that there was this intense public interest in. But that is just expedited because of how fast and easy information travels. But it's something that you know from trial work, and I know in trial work. Trials are crazy. You cannot predict what's going to happen in a trial. Trials are unexpected. And it's one of those things that when you are watching what's playing out in court, you never know what's going to happen. I don't think I've ever said I've never seen this before as much as I did in the Reed retrial. And I've never seen a retrial that had that many surprises. And I've done retrials. They're not supposed to be chock full of surprises. Like the surprise on a retrial is like it's harder to find this witness than it was before, or their answer is slightly different. And so you pull out a transcript. But to even having an expert have things on a resume that aren't on a resume, I've never seen happen, like ever. So it was a shocking retrial. I don't know if another trial is going to have that many twists and turns as we saw, and that many personalities. There's a lot of personalities in court. And then when you have a prosecutor in Brennan that has a similar style to Jackson doing both things, it's quite a lot. But I think interest is growing. But I also see a tension growing with the courts pushing back on that interest. We're seeing that in Utah with Corey Richins, that the court is really pushing back on having media in the courtroom at all and not wanting it streamed and wanting any access to the courtroom on delay. And so we're seeing a tension within judges of the negative side of having cases online. And it frustrates me that there is a downside, but it's also very much the reality that there is a downside. We saw the Murdaugh case get essentially swatted with a bomb threat called in while it was streaming. We heard from Judge Hippler in the Kohberger case how frustrated he was with the wave of people reaching out to the court about something that is outside of his control. And other judges are very aware of that. They see that and they say 100%, I don't want to deal with that. I don't want my courthouse to deal with that. I don't want my staff to deal with that. I don't want security to deal with that. I don't want this type of circus in my courthouse. Judges do not want the internet emailing them and saying, but this witness did this, and on this other time they did this. They don't want it. Lawyers, on the other hand, I think benefit greatly from having that many
They're
eyes
embracing it.
Yeah.
The lawyers are embracing it. I agree with you. And that's why I think people need to be careful. Like if you enjoy learning from this, watching these cases, they interest you, then act right, because I do think that people's actions can make this go one way or the other. We saw it with Chad Daybell versus Lori Vallow and the judge weighing, where the cameras are going to be, whether it's going to be recorded and played back later, just audio, like you said, in Richens. In Florida, it doesn't happen that much. The judges are pretty much like, yep, if cameras want to be here, cameras can be here. So every state's a little bit different, but I definitely think it could have a negative effect on it. And then you also have situations like Diddy where no cameras, federal court, and look, he got a fair trial. Nobody's going to say he didn't get a fair trial. So other judges can point to that and say, you don't have to have cameras to get a fair trial. And, the public, look, they covered that case perfectly fine. You got to sit there and sit in the courtroom. So it is something I'm really interested to see how it progresses. And I'm interested on, your take when you see cases handling it like Corey Richins versus, maybe it was in Karen Reed's case, civil versus criminal, right, is different in how they handle it. So I'm interested to see how that really progresses because it also has gone wild with, memes and tweets and TikToks and stuff like that. How do you think that's affecting the process?
I think it's something, again, that judges are mindful of, but attorneys are mindful of. And when you look at the tension with the judges of who controls the cameras, I like the way that Idaho did it. These are fixed cameras. That's it. It is what it is. It's up when it's up. Stream it. Anybody streams it. Everyone has the same access. No one has special access. But I also understand judges saying, you know what? I want to see the butts in the seats. I want to know who's responsible. Because if something goes sideways, I can point to the representative from whatever outlet and I have jurisdiction over them because they are in my courtroom. And it's not shocking to me that judges like that level of control where they don't have that level of control over the internet. I also understand why civil litigants are like, I don't want to be memed to oblivion if I just want to go to trial. I also have really big concerns about whether or not we will get good expert witnesses willing to be a part of cases.
Mhm.
When you look at criminal cases, the court can appoint experts for the defense, but I can see experts saying, if this is a televised case, my rates have gone up 3x and the courts haven't approved those rates, so I'm out. Because we even heard it from the ARCA witnesses, who I thought were great neutral witnesses, that
Yeah.
they were being doxxed, their kids were being doxxed, their spouses were being dragged online. That kind of behavior will make good witnesses opt out of high profile cases, which will harm the parties involved in those cases. It can also make good lawyers opt out. I'm sure there are lawyers that are like, the last thing I want is a case on TV. There's lawyers who are going to lean all the way in, but there's lawyers who are going to lean out. So I worry about that tension. It's frustrating that it can't just be observed. And I guess I shouldn't be frustrated by that, because we know this is reality, but I wish people could observe the trials as they are without trying to also intercede in them. It's
Mhm.
just no touching, no touching. We just watch it happen. But because it's in real time, people will want to be involved, or some will. It reminds me of parents fighting at like kids' sporting events. It's like, why are you rushing the ref at a soccer game? Stop it. It's too much. And I worry that that's going to cause a retraction of access to courts in this way, which is going to then lean back into larger media outlets only having access to cases because they can afford to pay teams to sit in court every day. And then we're back to just legacy outlets reporting cases through their lens. And I don't think that's what anybody wants.
Yeah, I never want to become part of the case, right? I don't want
No.
to break any news. I don't want people to give me inside info during the trials. Like, I don't want any of that. And
Nope.
that's kind of the hard part when you get into talking about this stuff. That's mainstream media. That's normal. That's what people normally want, what they want to get, what nobody else has. It's like, that's not what this is from our perspective as lawyers, right? You and I are explaining the process and answering people's questions and why is it like that? And what's a lawyer thinking when this happens? What can a judge do? What can't the judge? Like, that's part of the process of what this is. Trying to make this like a movie and these people are celebrities and it's like I want to become their friend and whatever it is, to me is it's a path that leads to somewhere that is very different than what we're doing now and not necessarily anywhere I want to be. And
Yep.
I think that pull for some people and even people watching, like they may think that they want that, but again, that's very different. That's like I know you're a big Bravo gal, so it's like that's Andy in the Bravo
Yep.
housewives and stuff, right? Like he knows them, he's in that world. It's very different than somebody that's just sitting around. What's it like to be a housewife, right? And that's what we're doing. We're just sitting around talking about what it's like to be a housewife. And it's like, I don't want to be like friends with everybody and going into it's like, hey, Alan Jackson just called me and this is what he's going to do with this witness, because that's not appropriate in our world. That's
Yeah.
not
I don't.
appropriate. I don't want a juror telling me what they're thinking as
Nope.
a trial is going on. That's not appropriate. And so there are just different rules to this. And that's why the interviews afterwards are cool. And you get to hear from the jurors and what did they think? And what were you doing? What were you thinking real time? That's all great. That's all good. But we have to be careful about how we handle where this is going, because as lawyers, I think most lawyers, most trial lawyers probably love the cameras and they want the cameras on them, like you said. But witnesses and normal people, just say, are built a little bit different.
Right.
And when it comes to like where we're going from here, lawyers are always so far behind when it comes to technology. So we're going to be kind of on the front part of this, and the rules and how the rules are written and what happens with them are always going to be years behind. So that's something we have to be cognizant of.
Absolutely. And when I look at the Reed case, just because it's most recent, you look at someone like a Karina Kolakithis, who I thought was a delightful witness. She saw what she saw. She did what she did. I related to her. She's like, my kids are giving me a hard time about never going out. So I go out and here we are. I long day at work and I didn't even want to be here. But even then, how disruptive that can be to someone's life just by going out to have drinks with friends. And it does concern me, because I don't want the courts to retract the access, because I think it's important for people to understand. And the only way to well understand our legal system, I think, is to watch it play out. And I think that's a very good thing, because I know more people understand the role of our legal system and how jurors work than they did before. And I don't ever
100%.
strive for people to agree with me. I just want them to understand why it is. And if they disagree with it, who then makes the rules and who do you talk to change those rules? Because our system is so complex with federal and state court and different jurisdictions. Helping people understand that I think is really important. Getting involved in it is definitely not what I want to do. I've been involved in it. Like, that's fine. I did that. I feel like, the injured athlete that's like, I'm going to go do commentary now. That's me. I'm like, I'm retired. I'm going to go do commentary now. I played this game. I've been on the field. I've done all of it. Let's just sit back and watch who's playing the game now. So I think that helps. But yeah, I don't want to be part of the story. I don't want sensational headlines. I don't title the cases with some kind of weird name, because I hate all of that. The cases shouldn't be titled after the worst thing that happened to the victim.
Mhm.
It's just state versus name. And so I really try to push back on that in the way I talk about things. I know you do too. This is what happened in court. This is why it's happening. This is what might happen next. This is the rules that bind us. This is how the law plays out. And when we don't know, I'm real comfortable, and I know you are too, saying, "Yeah, I don't know. I'm gonna have to look. This is a different jurisdiction. They
Lawyers
do
do.
things differently." Yeah.
Yeah. Lawyers research. We don't know everything. That's like the whole point of being a lawyer. And yeah, I think that when it comes down to it, people are learning more. They're becoming better jurors, better citizens, understanding the process better. They're less afraid of court.
Yeah.
And I think that's appropriate. They know what lawyers should and shouldn't do, because some people may need a lawyer at some point in their life. And they're seeing when access, like you're saying, is restricted and problems happen, that's part of the problem.
Yeah.
And that access would have helped with these problems. And I think there'll be a major pushback if they try to backpedal the access or cut off the access on a larger scale than maybe an individualized basis. And I think they should, because this is the people's government. This is the people's courtroom. And I don't think we need high sensitivity mics and listening to what the
No,
defense lawyers
definitely
say.
not.
But like you said, one camera with one view here, one camera with one view there, so they can just see the courtroom, is totally appropriate for me, for people's educational value. And that's the way I see it. People can say we're biased, obviously, because we talk about it, and that's fine.
Yeah.
We've also lived it and understand
Yeah.
what it's like in these cases, and how little people understand about the process, and how much harder that makes a fair and just outcome in certain cases. And that's really the big deal. Before we go,
It's
tell me
I
what's
will say on
next.
that,
Oh, go ahead.
before we
Yes,
go, I
yes.
will say on that, it is one place where I do give kudos to more corporate and legacy media, is because they will push back on gag orders. They will use legal process to push back for access. And that I do appreciate, is pushing forward to make sure there's transparency and access. All courts are set up really for Zoom court now. I don't see why we can't do it like C-SPAN with just a few fixed cameras, and give everyone the same type of access like they do in Idaho. I think it reduces some of the problems. And when a large community is involved, like in Canton, not everyone can fit in that courtroom. And it's not fair for the community to not be able to see what's happening with the judges that, depending on jurisdiction, they vote for, the lawyers in their community, and the police in their community. They should see that. And I do appreciate when media pushes back on that. If we have to have more of that, we will. We saw it in the Diddy case with I forget Matt's handle from the the Twitter account that does everything in these cases. He actually filed as an intervener because too much was sealed, and they said, "You know what, you're right," and they unsealed a bunch of stuff because of his action. So I appreciate that we're seeing that push pull, and I hope we keep seeing the courts being transparent, because it helps everyone. Because when the jurisdiction, people affected by that case, can't get into the courtroom, um, that's not access for them. So streaming is a good thing. We'll see what they do. But yes, now
And
we can wrap up with what's
well,
happening.
there are some good mainstream media people too. It's not
Yeah,
like we're saying everybody's better. There's some
no,
people that are really good.
100%.
I think the people that are embracing the new age and the new media are even better, right? And they can bridge that gap. And a lot of mainstream media have people like that, and they're so nice and great to talk to and
Yeah,
connect with and just talk through stuff. And I just think the way that it's going is so much better. Like, I watch YouTube or other stuff than what I used to watch, because I can watch what I like. I can start it when I want to. I can catch it live if I want to, but if I don't, I can start it and stop it and watch chunks of it. And whatever it is, people can watch what they like. They're not forced to where, like, if you like channel 13, whatever that is for you, you can only watch this one person talk about this issue. And it's like, ugh, as opposed to, what's Emily have to say about it? What's Peter have to say about it? And you can go and check it out and consume it the way that you want to, with people you trust, with everything that they say. You should know how people are when they put themselves out there like this and talk for hours and hours and hours on the internet, and it's recorded and out there forever. I like the way it's going, just even in the media that I consume, whether it's sports or whatever else. And I think it's good for this, whatever you want to call this, true crime, high profile cases, law tube, whatever the heck you want to call it. I think it's going in the right direction for where people should have access to these um, parts of their life, because there's no way around it. It's going to affect your life some way at some point, the justice system, either criminally or civilly, whether we want it to or not. So I think that access is really important.
And people can make up their own mind. When they can see it for themselves, they can make up their own mind on how a witness responded, a question that was asked, a judge's ruling. They don't have to have it filtered through anyone because they can just go watch the testimony for themselves, which when all you have is reporters sitting in the courtroom, it's rare now, and it's inner city press that really gives a judge said this, lawyer said this, question was this. It's rare to get a play by play. It's much more often that the reporting you're getting is still some type of editorializing, not just a straight play by play. And so when you have both, you can watch the play by play and get the commentary. I think it lets people decide if they agree, if they disagree, and brings better understanding. So I also think it's going in a good direction. I just hope that the boundaries of watch the thing, don't intercede in the thing, are respected.
And I just can't help but think, how many cases and trials does a large segment of the population think it is the way it is because one person that was sitting inside that courtroom said it?
Right.
And how different would it be if it was streamed? Like, there are probably so many cases in our own minds that we think back about in history that we think happened a certain way because one person told us it did. And that's the beauty. You don't even have to watch either of our shows and
Nope.
agree with us, because we're going to play it and you get to see how it is, and that's what's really cool about this, people having their own minds.
Yep.
Okay.
Agreed.
So you're streaming trials. You're not going to stop. We've got to figure out what is next. What's on your docket? What are you already following? And have you heard any whispers of any cases coming that you think might be interesting?
I am so down the rabbit hole on following marching band this summer that my docket is what it was before the Karen Reed trial, because I haven't even taken a breath to reset since we saw that the Kohberger case was pleading. But Adelson looks like she might actually go to trial in August. So we'll see if that actually gets off the ground. I'm skeptical. And we have a trial date finally for Corey Richins in February 2026. And there will be other trials that happen between there. I don't know if I will be following them because I haven't even reset. I still have like 1,000 pages of Lively Baldoni stuff that I've wanted to read that I just haven't. The lawyers write so much. There is so much motion work, and I'm just not caught up on it because of how busy everything has been. But there are civil cases. I'm sure I will be getting back into the Reed civil case. I covered a little bit, and that has had some litigation in between. And now that the criminal trial's over, there will be more litigation on that I'll keep an eye on. I want to know what's happening in the Idaho investigation. Of course, the sentencing of Koburger won't be the end of that investigation, I don't think. So that's the kind of broad view. I'm sure there will be more, but I'm not at this point touching into new cases just because summer's been incredibly busy. And it's weird having my 17-year-old out of the house on tour all summer. And so I've been really keeping up with that too. So it's that balance of where are we with trials? Where are we with work? And then where are we with family over the summer? And you're getting ready to go on vacation, aren't you?
I am soon enough. We will be in Greece. I'm excited. We'll see how it goes. I'm not a big international traveler myself. Not a big traveler, period. So we'll see. I'm looking forward to it. I'm gonna just do my best to just enjoy it and try to relax.
It will be lovely. I also have been dying for a follow-up. You went to see Jelly Roll, which is one of my favorite recent concerts because he puts on a great show. How did you enjoy it?
I loved it. I mean, I was surprised at how much I liked it. And I like Post Malone too. My wife got the tickets. There's like a bunch of her friends and we all went down to see it. So I didn't really care. I'm not like a big concert guy. If I am, I'd prefer Dave Matthews, which I know is that's your spot. I've
He's
only
not
been to
going
like
Florida this year. We're gonna have to do a Dave show at some point.
Yes,
Once you Dave with me and my friends, you will never go back. We have the most fun.
Okay.
But
Yes.
I'll
Jelly
be
Roll
in.
was awesome though. I really liked it. Post Malone was cool. I actually like Jelly Roll more than Post Malone, like performance wise.
Yeah.
I thought it was cooler. I really enjoyed it. I was surprised at how many of his songs I knew. I don't know who sings every song, but like I was surprised at how many of his songs I knew. And it was like pouring down rain, and they came out when the lightning stopped and still like performed in the rain. So it was kind of cool. to see it happen. Though I really enjoyed it. It was cool.
I love it. Jelly Roll is a great show. I always I joke because I go to concerts very frequently. I love live music. And during trials, I've been to numerous concerts as trials are going on because life happens. When I was doing trials myself, that wasn't on the table. Now I can make it happen.
Oh yeah,
So it's been a lot of fun because live music is one of my favorite things. So when I heard you were like, no, I'm going to go see Post and Jelly Roll, I'm like, oh, he's gonna have so much fun because
it
live
was
music
cool.
is one of my favorite things. So I'm glad you had a good time. He puts on just an incredible show, and it's fun to see because Jelly Roll's local to me. It's
Oh,
fun to see how much love and support there is too in Tennessee for him.
mhm.
They pardoned him from his crimes here in Tennessee. And really, he does a ton of work with the juvenile justice system here and elsewhere because of his time in incarceration, not just in juvenile justice, but as an adult. And if you haven't watched his talk to the Senate about fentanyl, watch it. It is
I'll
a
have to.
really powerful and incredible plea on we've got to deal with some of the drugs that are affecting our kids. And he's just a really interesting dude. But when we talk about the criminal justice system and there needing to be a balance between rehabilitation and how crimes are addressed, his story is incredibly interesting to me when he talks about, look, this was the lowest point in my life when I was incarcerated. This is where I found music. And this is where I'm striving every day to do something better. And it's a really good reminder that as we're watching these cases, especially in some of the less serious cases, which most of the ones that televised aren't, but that there still needs to be life after these cases for everyone involved. And I think his story helps remind people that there's life after all of the cases that we watch for everyone, witnesses, lawyers, parties. And so I appreciate him in that aspect as well, just encouraging people, look, you're not always defined by the worst thing that happens. You got to keep moving forward. And so I am a huge fan of his, but I love that he shares that story to remind everyone that the things we cover, there are people behind all of that. Everyone still has to move on with life. And I think it's easy sometimes for some that haven't worked within this system as much to forget that everyone involved still has to pick up and go on the next day. And that's not always easy to remember.
And there are redemption stories. Like there are
Absolutely.
people that do get rehabilitated that are in when you see them in their worst time, you may think they never will. You may think they're not worth it. They're not worth the try. They shouldn't get this. They shouldn't get that. Lock them, throw away the key. But yeah, I think that's great. And I think it's great when people get there and they still use their platform to look back and try to help other people and
Yeah.
let people understand a unique perspective they have that even though we've been in the system and understand it, different perspective, right? And he can bring
Absolutely
something to the
different.
table that other people really can't. So I do think that's cool. And he lays it out there too at his concert and tells his story and is really it's really like good vibes, like
It is.
really good vibes from Jelly Roll, which I thought was really cool. And again, I didn't expect that necessarily or know what was coming with that, but I thought that was awesome.
There's times
Um,
where like I'm at a rock concert, we're talking about weed, and now I'm at church. I don't know how
yes,
I got here,
it
but we've
was
done all of the things, and especially his show in Tennessee, there was a very large church component to it, and everyone was just like, absolutely. It was just, it's an incredible roller coaster, which is
yes.
again why live music is so good because humans getting together and enjoying a thing together is
Mhm.
just a really uplifting place to be. And we cover such heavy stuff. It's nice to have the lighter interactions with the public as opposed to the heavier interactions.
Yeah, absolutely. Absolutely. Well, we
It's
could
good to
probably
see
do this
you.
for a couple hours and we'll have to do it again, like I always say. But I appreciate you so much coming on. Everybody, is already subscribed to Emily D. Baker, but if you're not, go subscribe to Emily D. Baker. Almost 1 million subscribers. We'll get there soon.
I mean,
And
we'll get there. You hit 500,000. Look,
yes,
I love how many law nerds also love being part of the Lawyer You Know family and are just like, look, I love watching the different breakdowns, the different way we break things down, whether it's in summaries, whether it's me interrupting every 7 seconds and talking about what I'm thinking about. I love that there's something for everybody, and I think most of the time you and I are probably coming at the same thing from different perspectives and going, "Yeah, I agree with that." And
Mhm.
it's lovely to see how much your community has grown and how vibrant the conversations are and how respectful. I think what we've been able to build is a nice reminder that people can have conversations with each other and can disagree and want to find commonality. And it's a nice thing to remember because it doesn't always feel that way online. And I love seeing
Yeah.
it.
And I appreciate the cohesion, right? Because it's not necessarily there with everybody, but when there's mutual respect and for what people are doing, and you appreciate the way that they do it, even if vibes are different and personalities are different and perspectives can be different. Like, to me, that's what makes this cool. Like, that's what makes this work, is that there are different people with different perspectives. It's not just one person talking about every single case. So I always appreciate it. I always appreciate also Emily, for everybody that doesn't know, in the background, is helpful with anything, answers so many questions for people that are trying to do this and learn how to do it and understand how to do it. So that's always a big thanks that I have for you. And she does so many things that we can look at and be like, oh, Emily's doing that. We'll see how it works out. And then when it works out, we're like, oh, that's cool. Let's follow along those footsteps. So I always appreciate that. It cuts down the time for me on a lot of things. And I appreciate your takes on things. I think it's fun to watch. I love when people send me clips. I love some of the shorter stuff you do too. I always say it's hard for me to clip the trial. I'm just
100%.
listening. Yeah. But I love it. And I love to hear your takes. There's definitely times where I'll be like, oh, I got to go find this in the 7-hour stream. I got to go find this 10 minutes. And
well, we do timestamp it. So it's generally not too hard to find the moment, because I want to make it accessible for how people want to watch, what they want to watch. If they want to ride all day, if they just want to be like, ooh, this moment in court happened, I want to go see. Because I know a lot of our audience will watch with commentary or without, keep the chat up, and then we'll pop back in to see, oh, this thing happened in court, what's being said about it. And I appreciate too being able to, at the end of the day, be like, this is how I saw it in real time. Oftentimes you've gotten to watch it in real time, think about it, and then respond to it.
Very different.
It's always nice to see how you see something after you've thought about it. I'm like, oh, yeah, no, I totally see that. So I love, there's room for everyone online. I think having a lot of different voices helps. Every lawyer is going to attack a problem in a different way. And I think that's a really good thing to get to see, that everybody will look at a problem a different way and maybe understand why lawyers always say it depends, because it depends. And oftentimes we have conversations with other lawyers before we do anything. We are used to talking it out. And so it's nice to be able to do that online, and it's always great to see you.
Yeah, I appreciate it. All
Same.
right, until next time. That's
next
it.
time.
Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast, with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.